Thank you, members of the committee. Thank you for allowing me to testify today, and it's nice to see some familiar faces, and I wish you luck with this session. I think you've got your hands full. I got out of politics and decided to move to Bend and hang out over there and do some skiing, but I was in my office in 2008, and I got a call from this gentleman when I left, Larry Kirsch, who said that he asked if I was interested in working on an administrative law issue regarding health insurance, and I wouldn't get paid, but it might be interesting. And I said, well, sure, let's talk about it.
Like our job.
Yeah, thank you. Well, he was right, it was interesting. And it played out like this, that Mr. Kirsch is a healthcare economist, and he's the expert in healthcare, health insurance. It certainly is not a specialty of mine. But his wife contested a rate increase that was allowed to Regence Blue Cross Blue Shield. As far as I can tell, is the first person in the state of Oregon that's ever done that. I think in some ways this is uncharted territory, and we're the only ones that from outside the system that has actually opened the box and looked into it to see how it actually works. So, fine, she contested this rate increase, and the first thing you do is you ask for all the documents. Well, we got a stack of documents, and everyone was labeled confidential. So why do all these have to be labeled confidential, really? I mean, so after we pushed for a while, we made it so that about 99% of that information was released, and then the 1% we redacted, we blacked out so that their, quote, confidential information can stay confidential. But that was the first thing they did, was label everything confidential. And what I'd like to do today is just take a few minutes and describe what happened in this rate review process. And on my cover letter, I list 5 points that I want to hit, but really I'd ask you to flip to the third page, which says Summary of Events in Regence's 2008 rate filing. Okay? And as you'll see, February 29th, they asked for the rate increase. The amount they asked for was a 10.3% increase for that quarter, which would have amounted to a 26% annual increase. Okay, so that's what they asked for. So let's just focus, so we're comparing apples to apples, the 10.3% figure. That's what they asked for on a quarterly basis. Well, you can see on March 3rd, the actuary got back to them and they said, we strongly feel that only a 2% rate increase can be actuarially justified. The guy who said this was the gentleman Scott Fitzpatrick, who I think testified here last week. Very credible guy, had served 20 years in the Navy, I think in a submarine or something, before he became an actuary. That's what he put in his initial assessment, only 2%. So a meeting was set up on March 10th, and some of the Regence folks came, and they had their conference. And then a couple weeks after that, the department went on record and says, okay, we'll give you a 4% increase. That's what we're willing to do. Now, the next thing, April 1st, and by the way, I've attached behind this some of these documents that reference these so you can see this. April 1st, the guy from Regence sent him an email saying, no, we don't want your 4%. We'll go directly to DCBS. We're not going to take your 4%. The next event, and you'll see on my summary of events, it's question mark, early April. We don't know exactly what date. But there was this meeting that occurred between Corey Streisinger, the director of DCBS, Bart McMullen, the president of Regence. Okay, and it was in Corey Streisinger's office. I call it the secret meeting because there's no notes as to what happened at this meeting. There are no minutes. We don't even know the date. We do not know the date of this meeting. So what we do know is that Regence walked away with their full request. Okay? After a week or so after that meeting, it's disclosed the decision was made to give Regence their full 10.3% quarterly increase, which is 26% of the year. Now, April 8th, you'll see, there is an internal email from one actuary to the other called Gaming the System, where they talk about, well, numbers, you know what they say about statistics and numbers, you can yield any result you want. Okay, so they came out with a model that will somehow justify the full increase, and it was allowed. The last page in this packet says April 11th, 2008, reasons for approval. Okay, This is the one-page analysis, really, I guess, an explanation or discussion as to why they allowed this that cost Oregonians $30 million. Now, you guys, I know, are going to be scrambling for every $100 when you're doing the budget. This was a $30 million impact to Oregonians that was justified with one piece of paper. And if you look at this piece of paper and you'll see what's lacking, it's lacking any reference to legal standards. Okay, there is a statute, 742.005, and some of the other speakers talked about it, and the statute's really pretty general. It talks about things like prejudicial. Okay, it can't be prejudicial. Well, what does that mean? You can argue about what prejudicial means, and that's a whole other subject, and we're happy to go into that. But my point is that the approval makes no reference to legal standards. It makes no reference to any real methodology. It talks about, well, at first it was low, and then it was high, and then there's this number, and then this number, so boom, approved. Okay? That's the real system. That's the real system in the insurance division on approving these. Now, is what I'd like to go back to my front letter and I had 5 bullet points that I'd like to go through with you. The first bullet point I've already talked about, and that is the actual decision-making process is not made with respect to legal standards. The next point was that the rate increase was allowed against the advice of the actuaries. Okay, remember those emails? I can give you the long of this and the short of it, and I'm trying to give the short of it right now. But that secret meeting that occurred, there was no new information presented as far as we know. Okay, it's not as if the president of Regence came and said, well, what you need to understand is, and dumped a whole new set of numbers or figures or, profit information, loss. There were no new information. This rate increase was allowed against the advice of the actuaries. Okay? Point number 3. I've heard the insurance division argue that they're holding the line on costs and they're protecting the consumers because what they allow is less than what was requested. Okay? In other words, they'll say, all right, they came in and they asked for 30%, and we gave them, we approved 20%. So we're holding the line for consumers. And I think all of us can see that's pretty flawed. Negotiation 101. You start at this number when you're really willing to live with that number. And this is a really complicated thing, how you should address insurance rates. I'm not an expert at it, but I would ask you to keep this in mind. Just by coming down to a figure less than what was requested, that's not doing any good, okay? That is not rate review. That's not protecting consumers. The next bullet point, and this is on the top of the next page, This was information that came out in this hearing from this actuary, Scott Fitzpatrick, when I asked him in February of 2009 during the hearing. I said, well, Mr. Fitzpatrick, how many rate reviews have you done? And he says, oh, I've done a couple hundred. I said, okay. In how many of these rate reviews have you ever refused to eventually approve it, such that the insurance company actually needed to have a hearing? He said, 0. I said, you've had a couple hundred and you've never had the insurance company actually go to a hearing? And he says, no. He said, we're under instructions to always reach an accommodation. Go, well, okay. That's like a lawyer who has a reputation for being afraid to go to court. They always settle, okay? Once you know that's what the system is, you've got them over a barrel. Okay, there's no clout, there's no leverage, because you know they're not, at the end of the day, going to go to a hearing. Okay? And I just think that's the instructions that he gets. I don't blame Mr. Fitzpatrick, but I think that's the climate of the insurance division is you don't want to have that type of friction, you don't want to have that type of conflict. And I would actually look at it as a healthy thing. I think it would be a healthy thing to say, no, you know what, we're not going to go along on this rate increase unless you can justify it in a hearing. And I found it interesting that the earlier speakers spoke to that when they said, well, if there's a public hearing, the insurance companies, they don't want that, and they usually find a way to reach an accommodation. All I know is this insurance company never requires a public hearing in a rate review. Okay? The last point is that there's this transparency issue. And I don't want to be too harsh on the insurance division. I think things have changed in a couple days, over the last couple years. I do want to tell you that in my contested case hearing, I wanted to know what happened at the secret meeting, okay? I wanted to know what was said. So I served a subpoena on Corey Streisinger, okay, which I have had the power to do. They filed a motion against the subpoena, and the administrative law judge ruled in my favor and said, no, it's valid, you need to come. Well, the insurance administrator, Teresa Miller, said, no, I'm going to overrule the administrative law judge. Director Streisinger will not be required to come and testify, okay? And it speaks to the insurance division not wanting to disclose what happened. Now, if you ask Administrator Miller, if you ask Teresa Miller, she said, well, she was just following the advice of counsel. The Attorney General's office will say, well, we're just trying to protect her client, right? But I'm not really buying this because this isn't some corporate defendant. This is a state agency. This is a state agency that made a decision to cost Oregonians that cost us $30 million. And at any time they could have said, we want to come and explain what happened. We want to make the director available. We think this is information that you as a party in a contested case hearing, but more than that, the public is entitled to. Okay? And that is a concern of mine. I think the other speakers talked about transparency, and this insurance division needs to work more to create that kind of transparency. In my contested case process, the administrative law judge ruled against us. That's on appeal before the Court of Appeals. We have oral argument. I think it's on March 31st, and I'm not sure where it's going to go from there. But I do feel that we've looked in the box as to how this is actually done. Okay, I think Larry Kirsch and I are really just about the only ones outside of the system that have ever done that. I'm not here to present the solution. I think you heard some possibilities. Mr. Kirsch is the expert. I'm not. The thing I know for sure is that this rate system is not protecting Oregon consumers. Okay? I know that for sure because I've seen how it works. Okay, and again, I'd appreciate any questions, and I also want to thank you for your service sitting up on the panel, and you have a hard job. So thank you very much for your work on that.